Hi, everyone. It's Kristen McIntosh, the Happy Lawyer at Schweitzer and Associates, and thank you so much for joining the Happy Lawyers webinar this month. This is part of the Happy Lawyer webinar series, which takes place the last Wednesday of every month at noon. And for this month, we're going to be talking about celebrity estate planning mistakes. So let me share my screen for you. So this month, as I said, our theme is celebrity estate planning mistakes, and our webinar is There's No Business Like Snow Business, Celebrity Estate Planning Mistakes to Avoid. Before we begin, I do want to tell you a little bit about myself. As I said, I am Kristen McIntosh, the Happy Lawyer at Schweitzer and Associates in Garner, North Carolina. And yes, I really am a happy lawyer because I love working with my estate planning clients. I enjoy getting to know my clients personally so I can craft a unique plan just for them. I don't believe in any cookie cutter, one size fits all estate planning. Instead, I save my cookie cutter for these baked goods pictured here, which I give to my clients when they finish their matter with me. So today we're going to talk about such issues as not having a will and not updating your will. If you have a will, hiding your will, the dreaded do-it-yourself will, why you need to make sure if you make gifts to individuals or you want to make gifts to individuals after your death, that you put those in writing. So we're going to get started. The first estate planning mistake, number one, no will. The culprits here are Prince, Jimi Hendrix, Aretha Franklin, and Howard Hughes. So let's start with Prince as culprit number one. Prince, otherwise known as Prince Rogers Nelson, had an estate worth of $300 million when he died. Now, not preparing a will is a common mistake. In fact, it's estimated that approximately 60% of adults in America do not have a will. And unfortunately, Prince was amongst those. Now, let's remember, Prince was only 57 when he died. And I'm sure at 57, he wasn't expecting to die anytime soon. He probably thought he had another 30 years or so to live. And I'm sure, like a lot of people, he thought, oh, I can get around to doing a will later on in life, a couple of years from now. I don't need to do it now because I'm not going to die. But unfortunately, as we all know, death is unpredictable. So when Prince died with leaving $300 million, he did not have a will. And so what happens when you don't have a will is the state steps in and decides who is going to inherit from you and what amount they're going to inherit. Now, the state does not care whether or not you like those individuals. The state does not care if you've ever talked to those individuals. If they're in the statute, they're going to inherit under the intestate statute. And intestate is a fancy way of basically saying dying without a will. So unfortunately for Prince and his six and a half siblings and half siblings, they did not like the intestate statute, and they have spent several years fighting over who gets what and how much. And you know who's earning a lot of money with all this? The bankers, the financial planners, and the estate planning attorneys. You know whose inheritance is shrinking bit by bit through all these fights? You guessed it, the heirs or potential heirs. So culprit number two is Jimi Hendrix, who died at the young age of only 27. Hard to believe he was only 27 when he died. And of course, like most young people, Jimi Hendrix thought he was going to live for a very long time. I mean, after all, he was a rising star. He had already accumulated $80 million in wealth. So why would he need a will? Besides, he had a father, Al, as well as a brother, Leon, whom he was close with during his lifetime. And those were the people that I'm sure Jimmy would have wanted his money to go to. So why do a will? Because they'll be the ones to get the money, right? Well, here's what happened with that plan of Jimmy's. You see, when Jimmy died, since he didn't have a will, the state gave his entire estate value net worth of $80 million to his father, Leon or Al. Now, after Jimmy's death, Al and Leon must have had some type of fallout because Al changed his will. Yes, Al did have a will. And in Al's new will, he disinherited Leon. Instead, he made his adopted daughter the sole heir of his estate. So when he died, whatever was left of Jimi Hendrix money or the money that he had inherited from his son Jimmy passed not to Leon, who was Jimmy's brother, but to the adopted daughter, who was a stranger to Jimmy. Now, I'm sure that Jimmy would not have wanted this to happen, but unfortunately, I have to have this conversation with a lot of my clients that you can't control from the grave. And what that means is once you leave somebody your property or money through your will, when you die, they receive that property and or money, and it's theirs. They can do with it whatever they want. It doesn't matter if they promised you during your lifetime that they will pass it on to their children or to their spouse. If they change their mind after you die, they can give it to whomever they want to do. So don't be like Jimmy and leave it up to chance. Now, culprit number 3 is Aretha Franklin, the Queen of Soul herself, who taught us R-E-S-P-E-C-T. Now, she had a very long musical career and was still singing at the ripe old age of 76. Now, when Aretha died, although she had been married and had children, in fact, she had 4 sons, she did not have a will. But at the time, I'm sure Aretha intended for her entire $80 million estate to be split equally amongst her 4 sons, which would mean that each son would receive $20 million. And that's exactly what the intestate statute stated. Well, the problem in Aretha's case is that one of her sons was incapacitated, and he ended up, before her death, having to have a guardianship instituted, and an adult guardian was appointed to oversee her incapacitated son. Now, this person was not a family member, and while I imagine that Aretha knew this person, she may not have known this person very well. So, and most likely, since her son was incapacitated, he probably was receiving Medicaid. Now, when you're receiving Medicaid, you have to have a very limited amount of money each month. And receiving a $20 million inheritance would obviously kick you out of any Medicaid program. Now, some people would argue, that, hey, you have $20 million, you can afford your own medical care. Well, in some cases, you would be correct, except let's not forget there's a guardian at play. Now, this individual now, through the guardianship, has access and control over that $20 million inheritance that the son would have received from his mother. Now, the better way for Aretha to have approached this is, one, she should have had a will. But not only should she have had a will, she should have created either within the will or as a separate estate planning vehicle, what's known as a special needs trust or a supplemental needs trust. What that is that enables somebody who's on Medicaid to have their inheritance, in this case, the $20 million inheritance, to bypass themselves and go into this trust, who would be managed by a person of Aretha, in this case, choosing. And that person would be able to use that $20 million not to pay the medical bills, which were covered by Medicaid, but to pay for such essentials, non-essentials, such as, trips or TVs, those kind of items. So if you have a special needs child or spouse, you probably want to consider a supplemental needs trust. And if you want more information about that, feel free to reach out to me. Now, culprit number 4 is Howard Hughes. And I included him because I don't want you to think that musicians are the only people who forget to leave wills. In this case, Howard Hughes was a billionaire. When he died, his estate was worth $11 billion. That's billion, not million. And unfortunately for Howard, he had no family and no descendants. He also didn't have a will or a trust. Now, because he had no family and no descendants, Howard did not have the traditional intestate statute couldn't apply for Howard. So what ended up happening was people came out of the woodwork all claiming all or a portion of his $11 billion estate, and several lawsuits ensued. And essentially it took 34, yes, you heard me right, 34 years for his estate to end up being resolved. Now, as you recall from earlier in this presentation, guess who made a lot of money in this 34 years of lawsuits? Yep, the bankers, the financial planners, and the attorneys. I'm sure that's not whom Howard Hughes wanted to receive a large portion of his inheritance. Now, estate planning mistake number 2. Not planning for children. Here, the culprit is Heath Ledger, who was Hollywood's golden boy until he died unexpectedly at the age of 28. Now, unlike the other 4 celebrities that we just finished discussing, Heath actually had a will. In his will, he named his mother or his parents and his 3 sisters to inherit his estate. Great planning, right? Well, after Heath had done the will, a short time later, he met Michelle Williams, a lovely actress, and went on to have a child with her. And that child is a daughter named Matilda. And when Heath died, Matilda was 2. And for whatever reason, Heath just didn't get around to changing his will or forgot that perhaps he should update his will now that he had a daughter. So what ended up happening is when he died, his parents and 3 sisters received his full inheritance and Matilda got nothing. Now, luckily, this story has a happy ending in that his parents and sisters knew that Heath would have wanted to have provided for Matilda. So they ended up giving Matilda all of their inheritance that they received from Heath. Now, granted, this was a great thing. They weren't legally obligated to do so, but they felt morally convicted to make sure Matilda was taken care of. But we can't always trust that our family members would do likewise. I mean, how many people out there can honestly say if they receive $28 million that they would say, oh, I don't need it, you can give it to someone else? Probably not a lot of us. So that brings us to estate planning mistake number 3, which is not updating your will. Now, the culprit number 1 here is Barry White. Now, Barry White lived a long life. You know, he was the let's get it on singer. And Barry had been married, not once, but twice. He was divorced from his first wife. Second wife, he was separated from and had been estranged for several years. But he had since moved on and had been living with a girlfriend. And he was still living with that girlfriend when he died. Now, Barry also had 2 children, Denise and Daryl, from his marriage to wife number 1. Now, when Barry was married to wife number 2, he created a will. Good, Barry, right? Barry did the right thing. Well, in his will, Barry left everything to that wife because I'm sure at the time he really loved her. Well, obviously, his feelings changed, and while he separated from her, he never updated his will. So when he died, guess who got his entire estate? Wife number 2, because Barry had failed to update his will. So she received the assets, leaving the girlfriend and his 2 children without anything. Now, granted, a long court battle ensued, and we're not going to get into what ended up happening, but the fact of the matter is a lot of grief was created. And I think most people would agree that Barry probably would have preferred that his girlfriend and or his 2 children should have inherited his estate and not the ex-wife. I mean, how many of us have really good relationships with our exes? I'm sure there are some out there, but probably not a lot of us. And that brings us to culprit number 2, Whitney Houston, who was one of the best-selling recording artists of all time. Now, Whitney actually had a will, which is good because she had a daughter, Bobby Christina, when she died. And at the time that she died, her estate was worth $20 million. And in her will, she had tried to do the right thing in the fact that she gave Bobby Christina 10% of her estate when Bobby turned 21, and then the remainder of the estate at different intervals of time. Now, the problem is when she created her will, Bobby Christina was a small child. And at that time, Whitney had no idea how responsible Bobby Christina would have been. So when Bobby Christina was 18 when Whitney died. And when she turned 21, she received $2 million outright and freed of hers to do what she wanted. And like most 21-year-olds, Bobby Christina did not make the best decisions. Unfortunately, Bobby Christina turned to a lot of excess partying and drinking and drugs, and ultimately ended up dying in 2015. Now, the reason I'm bringing this up is I think most of us could agree that most 21-year-olds are not mature enough to handle receiving millions of dollars. Okay, so because they make silly decisions. They're not exactly thinking, hey, I should be saving for a down payment of a home. They're thinking, hey, I'd like to have that Lamborghini. So Whitney probably should have met with an estate planning attorney and changed her will, or when she originally did her will, should have planned out greater age increments. I like to recommend 25 as a minimum age that a child should receive an inheritance, because by 25, most children are becoming more financially responsible. So that's why Whitney's on this list. Estate planning mistake number 4, the dreaded oral promises. Now here, the first culprit is Marlon Brando. Now, Marlon Brando did the right thing. He had a will. Yay, Marlon. But Marlon also had a housekeeper whom he apparently liked very much. And according to the housekeeper, Marlon allegedly told her that when he died, she could have his $627,000 home. Unfortunately for the housekeeper, Marlon never put that promise in writing. He didn't, change his will to add the caveat that his housekeeper should receive his house, nor did he execute a deed giving the property to the housekeeper during his lifetime. So of course, what ended up happening is, Marlon unfortunately died, and the housekeeper essentially was kicked out of the home. And although she tried to fight it, she ended up not prevailing, although she did receive a $125,000 settlement. But that's pretty much chump change considering the fact that the house was worth $627,000. So, moral of the story is, if you want specific property to go to specific people, don't just tell them they can have it, put it in writing. Culprit number 2 is Steve McNair, who was a professional football player. Now, Steve was a good son during his lifetime. He bought his mama a house, $1 million home for her to live in, and he intended for her to have it as her own and wanted her to have it when he died. Unfortunately for his mother, Steve never executed a deed transferring the property to his mother during his lifetime. Steve also never included the provision that the home should go to his mother when he died in his will. Now, when Steve died, he was married. And of course, the wife went to her mother-in-law, Steve's mother, after Steve had died, and told her, the house is mine, it's not yours, and if you want to stay here, you have to pay $3,000 in rent every month. Well, of course, the mother couldn't afford that, so she ended up moving out of the home. Well, to add insult to injury, Steve McNair's estate, through the wife, ended up billing his mother for $53,363 for appliances and other items that she allegedly took from the home. Now, do you think Steve intended for that to happen? No. But again, Steve made an oral promise to his mother, but his wife did not honor that oral promise, nor was she legally obligated to do so. And long story short, mother ended up homeless and owing the estate a considerable sum of money. Final culprit in this scenario is Ted Williams, who was a professional baseball player. Now, this doesn't have to do with any assets, okay? Nobody cared what or worried about what was in Ted's will as far as who was to get his $5 million estate. That's not what the fight was in Ted's case. Instead, where Ted was concerned, it had to do with what was going to happen to his body when he died. You see, in his original will, when he created it, Ted wrote that he wanted to be cremated. Apparently, later on in life, Ted changed his mind, according to two of his children, and decided he wanted to be frozen. And they actually had a piece of paper where he actually stated that he wished to be frozen after his death. Well, that was presented after he died and against his oldest daughter's wishes, who insisted that he wanted to be cremated. Ted's body was actually frozen. The eldest daughter spent a lot of time and money filing a lawsuit, trying to have her father's body declared to be unfrozen and then cremated. Unfortunately, she ran out of money, and Ted remains to this day, to the best of my knowledge, frozen. So the moral of this story is, if you have dictated what you would like done with your body, whether that be buried, cremated, or in Ted's case, frozen, and you've put that in your will and you later change your mind, then what you need to do is to change your will, either write a whole new will or execute what's called a codicil, which is a document that goes along with your will to change your wishes. Estate planning mistake number 5, the secret will. Now, the culprit here is Florence Griffith Joyner, FloJo. And we've talked a lot, so far in this presentation, we've talked a lot about what can happen when you don't have a will or when you fail to update your will when life changes or you make oral promises to someone. But can you imagine making a will and then hiding it from everyone and not telling anyone where your will is located? Well, that's exactly what FloJo did. You see, FloJo told her family she had a will. Everybody knew FloJo had a will. However, FloJo put her will somewhere and did not tell anybody where her will was located. So what ended up happening naturally is FloJo died and no one could find the will. So essentially, because no one can find the will, it was treated like FloJo did not have a will. And guess what? The intestacy statute came into play. Well, of course, this resulted in several lawsuits because, people claim that, hey, FloJo told me she had a will, and in her will, she was leaving me this, and so I should receive the property. I don't care what the statute says. This went on for a while. And the reason I'm bringing this up is that if you have a will, please tell someone that where your will is located. And more importantly, tell your executor, at least, and better yet, give your executor a copy of the will and or your estate planning attorney. Now, I know when I do an estate plan for my clients, I always keep a copy of the signed will in my files. I also write in my files where the individual tells me that he or she is going to place the original will, because every once in a while I will get a phone call from someone saying, hey, mom died and we can't find the will. Well, I'll go look in the file and I will tell the person, hey, according to what your mom told me when she executed your will, this is where it should be. Hopefully that's where the will is. So that brings us to estate planning mistake number 6. The dreaded do-it-yourself will. Now, there are a lot of programs out there and a lot of people who think that they can do their own will. And yes, you can. But the question is, should you? Now, interestingly enough, the culprit here is Chief Justice Warren Burger. He was the Chief Justice of the United States court, and he had an estate worth $1.8 million. Now, obviously, Chief Justice Warren Burger was a lawyer. And some of you are going to sit there and say, well, aren't all lawyers supposed to know how to write wills? And the answer is yes, we're taught that in law school, but if you don't do estate planning as a living or on a regular basis, you may not know all of the proper paragraphs that need to be in the will that pertain to tax saving advantages, powers that your executor may need to have in order to carry out your wishes without court intervention. And see what happened in Warren's case. I mean, he typed up a will, but get this, it was 176 words. Yeah, you heard that right. 176 words. Now, brevity can be great in a lot of cases, but when it comes to your will, it's probably not a good idea to have a very short will, especially if you have a $1.8 million estate. So what happened when Warren died? Well, his family ended up paying $450,000 in taxes. Now, a good estate planning attorney would have drafted the will so that his heirs would have paid considerably less, or perhaps would not have paid anything in estate taxes. So that just created a whole mess for his heirs, who ended up losing a big chunk of their inheritance to the IRS. And I'm sure that Warren would have preferred that his family receive that money as opposed to the government. But unfortunately, he decided to do his own will. So the moral of the story is, if you think about doing your own will, please don't. Estate planning mistake number 7. The failure to fund. Now, in this case, our culprit is Michael Jackson. We all remember Michael Jackson. He was the first person to moonwalk across the stage and made the wearing of the one-handed glove cool back in the 80s. As an 80s child, I still remember, the sparkly glove. Anyway, he died leaving an estate of $600 million. And like he should have done with an estate of $600 million, Michael actually created a trust. Beautiful. That is a perfect document to create when you have a value of $600 million, because the trust theoretically would control who would get the money, and you could control how the money should be distributed. You have a lot, in other words, you can control from the grave with a trust. Now, unfortunately for Michael, he made the mistake that a lot of people do when they create trust. He forgot to fund the trust. You see, think of a trust as a storage shed, an empty storage shed. Until you actually put something in that shed, it's essentially just an empty storage shed. So Michael, unfortunately, never, executed any deeds transferring real estate to the trust. He never opened up any bank accounts in the name of the trust. He put nothing in the trust. And surprisingly, Michael's attorney apparently did not create what's called a pour-over will. Now, a pour-over will is something that I always create for my clients when I create a trust for them. And essentially, that is a will in which it states that everything that you own in your personal name at the time of your death gets automatically transferred into the trust when you die. Now, if Michael had had a pour-over will, problem solved, everything would have transferred into that trust. But apparently he didn't have the pour-over will. And since the trust had no assets in it, that left everything up to the dreaded intestate statute. And it just created a whole mess. So moral of the story is, if you pay a lot of money for a trust, you should fund it. Estate planning mistake number 8. The unclear intent. Now here we turn to England with Princess Diana of Wales. Now she died in 1997 and she left a very detailed will. In that will, she named her mother and her sisters as executors, and she spelled out exactly how she wanted her estate to be distributed. Now, in addition to the will, she also wrote a separate, quote, letter of wishes, unquote, asking her executors at their discretion to divide approximately £100,000 worth of property between her two sons, and Prince William and Prince Harry, and her 17 godchildren. Now, she wasn't clear how that property was supposed to be divided. She wasn't clear as to which person should receive what property. So her mother and her sisters, as her executors, ended up giving each godchild one little trinket and the rest to her sons. Now, maybe that's what Princess Diana would have wanted to have happened, but something tells me that that's not what she would have wanted. But the problem is she wasn't specific. So her executors got to make up their own minds and decide what they would want to happen, and not necessarily what Princess Diana would have wanted. And that brings me to my point that if you want to leave individuals specific items of property, you should state your desires and list those specific items of property in your will. That way you're guaranteed that the property will pass to that person. Or if you don't want to leave it in your will, or you later change your mind, you can execute a separate written document similar to what Princess Diana did, where you specifically list the property that you want to go to the specific person. Now, it's important that you describe that property as descriptively as you possibly can, so there's no confusion. And it's a good idea to use first, middle, and last names. And if somebody's a junior or a third or a fourth, make sure you include that as well, so there's no dispute as to which John Charles you wanted to inherit the property. And most importantly, if you do that separate written document, make sure that you sign and date it and keep it with your will, so your executor will find it. So to recap, I can't stress the importance of making a will if you don't already have one. And if you do have a will, make sure you update it when life changes happen. So it's just a change in your marital status, or maybe you go from not having children to having children, or a spouse becomes disabled or ill. And if you don't have and please remember to put all oral promises in the will or in that separate document we talked about earlier. And please try to resist the temptation to write your own will. It'll save you a lot of heartache, or your heirs a lot of heartache in the end, if you see an estate planning attorney to help you with your will. And finally, please don't hide your will. There's no reason to keep your will secret. I mean, there has to be at least one trusted person that you know that you can tell the location of your will. So I hope you enjoyed this webinar and found it, somewhat entertaining and informative. Hope you found it very informative. And if you need any further information, please don't hesitate to reach out to me at kmcintosh@nclegalcounsel.com. You can visit our website at nclegalcounsel.com for more information, or follow us on Facebook, Instagram, or LinkedIn at Schweitzer and Associates. And I hope you'll tune in next month when we have our next webinar in February. So thanks, everybody, and I hope everybody has a great day. So again, thank you. And as we all know, until next time, stay happy.